volume 3, PDF page 104. Documents volume 3, PDF 104.
That is the acceptance by Parliament.
Yes,
Of the reorganization.
He moves the resolution, Millet. Amit Shah moves the resolution. It's just important to read it.
Supplementary list of business.
Yes. Says that the President of India has referred the Jammu and Kashmir Reorganization Bill to this House under the proviso to Article 3 of the Constitution for its views. For its views, as this House is vested with the power of the state legislature of Jammu and Kashmir, as per the proclamation of the President of India dated 19th December 2018, this House resolves to express the view to accept the Jammu and Kashmir Reorganization Bill. And then Millard's the speech to the statutory resolution and what he says when he moves it. And that's at page PDF 105, that this House recommends. So that's the understanding throughout. This House recommends the following public notification to be issued by the President. An exercise of the powers conferred by Clause 3 of 370, read with Clause 1 of 370, the President, on the recommendation of Parliament, is pleased to declare that as from 5th August, all clauses of the said Article 370 shall cease to be operated, except Clause 1 thereof, which shall read as under, that all the provisions of this Constitution as amended from time to time, without any modifications or exceptions, shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in 152 or 308, or any other article of this Constitution, any other provision of the Constitution of Jammu and Kashmir, or any law, document, judgment, etc. The President has referred the Jammu and Kashmir Reorganization Bill to this House under the proviso to Article 3 for its views. And then
the presidential notification, which is page 1.
Just one other thing, and then if your lordships kindly come back to the first CO202, just for a minute, Mullah.
What page would that be?
Yes, 101, PDF 101. Is it?
This document one is what?
PDF 101, same document, volume 3, same one. Just above this.
Page 494.
Yes. So it's not just the substitution of definitions. It's much more than that. I just wanted to point that out. That in exercise of the powers conferred by Clause 1 of 370, the President, with the concurrence of the state of Jammu and Kashmir, is pleased to make the following order. He makes that order, and that it shall come into force at once, and shall thereupon supersede the Constitution application to Jammu and Kashmir Order 1954 as amended. So it's not just 367. And then all the provisions of the Constitution as amended from time to time shall apply to the state of Jammu and Kashmir, and the exceptions and modifications subject to which that shall so apply shall be as follows. So will they supersede the 54 order, apply all the provisions of the Constitution, and then the 367. So it's not just the interpretation. That's all I wanted to point out. Now let's kindly come back to the list of dates so that we can, that is written submissions compilation volume 2.
Yes.
and we were at 77. We've already read 77 in the sense that I have read it from the Amit Shah's, from the Home Minister's, the introduction. And then 78 is 9th of August 2019, in exercise of the powers under Section 2A of the Jammu Kashmir Reorganization Act. On receiving the assent of the President, the respondent through the Ministry of Home Affairs issued a notification for the provisions of the Act to come into force with effect from 31/10. Then, of course, the writ petition is. Sorry. I'm sorry.
And then the petition and then,
And then, 31st of October, pursuant to the notification SO
the
28.
bifurcation into Ladakh and Jammu and
So
Kashmir.
that's what happened. So that's all, the facts are concerned. Now, kindly,
Yeah.
just, so therefore we are dealing with three issues. 356 power, CO202, CO203, 273. Now, just let's keep three principles in mind, which are going to be my key submissions. It's my submission to your lordships that when interpreting all these executive orders and the constitution, three principles must be kept in mind.
Yes.
The first is that the clear language of these provisions in its structural and historical context. The clear language of these provisions in its structural and historical context ought to be given effect. And it is our contention that the language of the provisions is clear, unambiguous, and on its own terms must be given effect. You can't find ambiguity where none exists. So that's the first principle. Yes. Second, if there is a textual ambiguity, the court should not be adrift in a sea of pragmatism. And the court must interpret that.
If there is structural ambiguity,
if there is any textual ambiguity or the possibility of trying to find another possible interpretation, let's put it that way.
The court should not be adrift in a sea of
pragmatism.
And
Malaj, the interpretation that is more consistent with our constitutional values. An interpretation that is more consistent with our constitutional values, namely representative democracy and federalism. Representative democracy, federalism, and constitutional morality should be preferred.
could you repeat that again, Mr. Simbal?
Malaj, that if the
Second part.
if there is a textual ambiguity or a possible alternative interpretation by stretching your mind a bit, then, Malaj, we must interpret those provisions. We're not adrift in a sea of pragmatism. We must interpret those provisions consistent with constitutional values, federalism, representative democracy, and constitutional morality.
that's the second.
That's the second.
And the third?
That will ensure the smooth and harmonious working
In fact, that's the third one.
of the Constitution.
Written submissions which you give.
So I'm just putting it, and the third is that any power vested by or under the Constitution is in essence a limited power. There is no unlimited power vested in any institution under the provisions of the Constitution. It's a limited power. It is limited at the point of time when it is exercised. It is limited at the point in time when it is exercised. And limited by core constitutional principles or values, both in terms of time and core constitutional principles and values. Since no power is absolute.
Yes.
And therefore must be exercised in accordance with the provisions. This is my fundamental premise, on the basis of which your lordships, I beseech, will try and interpret the Constitution in the manner that I have suggested.
Yes.
So, Malas, if you look at it from the standpoint of these principles, and you apply them to Article 3, Article 356, and Article 371D. Apply these to these three articles. This is the exercise of executive power.
356?
371D, Manas. The answers, according to me, are evident. Why? I just presently say. The power under 371D does not extend to abrogating 370. By applying those three principles. The power under 356 minutes does not extend to making non-restorative, permanent alterations, non-restorative permanent alterations to the state's constitutional status. That's on Malat's 356. And the power under Article 3 does not extend to effacing the character of the state into a union territory. The power under Section 3, Article 3, does not extend to effacing the character of a state into a union territory. So therefore, it is the interaction.
Yes.
Interactive dimensions, the interaction of the values of constitutional values and federalism, separation of powers, and democracy itself that are at play. And that's, with the greatest respect, how your lordships be kind enough, Mullahs. And therefore, Mullahs, the question that arises is there a limit to the emergency power? Or is it unlimited? That's what they are trying to do in using 356 to change the whole structure. So is it unlimited? Can emergency be passed to used to make permanent constitutional changes? Is it an unlimited power? Can it be used to make permanent constitutional changes? Permanent and irreversible. And can the constituent power be equated with ordinary powers? Effacing the source of their authority. Constituent power is a separate genus of power. Can it be equated with ordinary legislative power? It can't. And can constitutional change, last of all, happen without consultation with the people, despite consultation with the people of Jammu and Kashmir, despite an express provision in that regard. And last of all, can the state be downgraded to a union territory by the union on its own women fancy without consultation with the people affected? Those are the constitutional parameters that I respectfully state should apply when dealing with this momentous change that was brought about by exercise of majoritarian executive power. Now, Malad, I'll take your lordships to some of these decisions. First of all, Malad, 356. Let me, Malad, straight away come to 356. We'll come to Bomai, Malad. Volume 2, Case Law Compilation. Volume 2, at PDF page 120. 113, sorry, Malad. 113 first. 6. Oh, yes, 113, sorry. No, that's right, 113. PDF page 113. Yeah. Paragraph 96.
Volume 2.
Just a Jeevan Reddy judgment or?
Says,
Justice Sawant.
yes. Justice Sawant. Now, with para 96, my lords have that?
Yes.
It will be inexcusable, it will be an inexcusable error.
113.
113, running page 260. 7.
CNC.
May I read, Malad?
Para 96.
96. It is inexcusable, it will be an inexcusable error to examine the provisions of Article 356 from a pure legalistic angle and interpret their meaning only through jurisdictional technicalities. The Constitution is essentially a political document, and provisions such as 356 have a potentiality to unsettle and subvert the entire constitutional scheme. The exercise of powers vested under such provision needs therefore to be circumscribed to maintain the fundamental constitutional balance, lest the Constitution is defaced and destroyed. This can be achieved even without bending, much less breaking the normal rules of interpretation. If the interpretation is alive to the other equally important provisions of the Constitution and its bearing on them, democracy and federalism are the essential features of our Constitution and are part of its basic structure. Any interpretation that we may place on Article 356 must therefore help to preserve, not to subvert their fabric. The power vested de jure in the President, but de facto in the Council of Ministers, under 356 has all the latent capacity to emasculate the two basic features of the Constitution, and hence it is necessary to scrutinize the material on the basis of which the advice is given, and the President forms his satisfaction more closely and circumspectly. This can be done by the courts while confining themselves to the acknowledged parameters of the judicial review as discussed above, illegality, irrationality, and mala fides. Such scrutiny of the material will also be within the judicially discoverable and manageable standards. So that's the first paragraph. Then 106, PDF 119. Thus, the federal principle, social pluralism and pluralistic democracy, which forms the basic structure of our constitution, demands that the judicial review of the proclamation under 356 is not only an imperative necessity, but a stringent duty, and the exercise of power under the said provision is confined strictly for the purpose and to the circumstances mentioned therein, and none else. That's very important. The purpose of 356 is to restore democracy. That is why this is very important. So you must interpret whatever the actions of the government are in the context of that purpose under 356. It also requires that the material on the basis of which the power is exercised is scrutinized circumspectly. In this connection, we may refer to Dr. Ambedkar, what he had to say in reply to the apprehensions expressed by other honorable members of the Constituent Assembly in this context, which also brings out the concerns weighing in the mind of honorable members. In regard to the general debate which has taken place, in which it has been suggested that these articles are liable to be abused, I may say that I do not altogether deny that there's a possibility of these articles being abused or employed for political purposes. So this is not something that I am saying on my own, Mullah. This was envisaged. But that objection applies to every part of the Constitution, which gives power to the center to override the provinces. In fact, I share the sentiments expressed by my honorable friend, Mr. Gupte, yesterday, that the proper thing we ought to expect is that such articles will never be called into operation, and that they would remain a dead letter. If at all they are brought into operation, I hope the President, who is endowed with these powers, will take proper precautions before actually suspending the administration of provinces. I hope the first thing that he will do would be to issue a mere warning to a province that has heard that things were not happening in the way in which they were intended to happen in the Constitution. If that warning fails, the second thing for him to do will be to order an election, allowing the people of the province to settle matters by themselves. It is only when these two remedies fail that he would resort to this article. It is only in those circumstances he would resort to this article. I do not think we could then say that these articles were imported in vain or that the President had acted wantonly. Time and again in the history of this country, 356 has been misused by all regimes. That was never the intent. And now, in this, in changing the structure of this Constitution as applicable to Jammu and Kashmir, it has crossed all limits. See what happens. 20th of June, Malaj, 19th of June, sport withdrawn. 20th of June, governor says, and suspended animation. 20th of November, an attempt is made. Well, there is some ambiguity in that, to form a government. 21st November, dissolution. Can't be done without the aid and advice. Then, after 21st November, 19th December. Then 356. Then 3rd of July. Extended. Then 5th of August. Where are the steps for the restoration of democracy? Where are those steps? In fact, the steps are just to the contrary, the reverse of it. Destruction of democracy. People are not taken into account. Their views are not taken into account. You arrogate to yourself the powers of the state. You arrogate to yourself the powers of the legislature. Parliament becomes the spokesperson of the people of Jammu and Kashmir. And you express the wishes of the Jammu and Kashmir Assembly through Parliament. When the Constitution requires you to take the views of the state, of the legislature, of the people of Jammu and Kashmir, who gave to themselves the Constitution of Jammu and Kashmir. Everything that is done under 356 is contrary to the basic principles of both federalism and democracy, and to the principle of constitutional morality.
Yes, please.
Then 108 minutes. The further equally important question that arises in this context is whether the president, when he issues a proclamation under 356, would be justified in removing the government in power or dissolving the legislative assembly, and thus in exercising all the powers mentioned in subclauses A, B, and C of clause 1 of Article 356, whatever the nature of the situation or degree of the failure of the constitutional machinery. A strong contention was raised that situations of the failure of the constitutional machinery may be varied in nature and extent, and hence measures to remedy the situation may differ both in kind and degree. It would be a disproportionate and unreasonable exercise of power if the removal of government or dissolution of assembly is ordered when what the situation required was, for example, only assumption of some functions or powers of the state, government of the state, or of anybody or authority in the state under 356(1)(a). This is not the only power that you can exercise under 356. There are incremental steps to be taken. This is not a guillotine provision. And it's temporary, to say the least. So unless your lordships come down heavily, that 356, the excessive use of power also amounts to illegal, irrational, and mala fide. So your lordships will have to determine, was this not an excessive use of power? And per se it would be illegal, mala fide, and irrational. Hence it is urged that the doctrine of proportionality is relevant in this context and has to be applied in such circumstances. To appreciate, that's why I said, in normal circumstances, dissolution would never happen. First, the assembly would be suspended, be in suspended animation. Attempts would be made to form a government. In the meantime, you exercise president's rule. When you realize that it's just not possible at all, it's then at that stage that you dissolve the assembly and order elections. Now you've dissolved the assembly. When did you dissolve it? On 21st of November 2018. And we are where? In August 2023. Was that meant to be, under 356? Hence, it is urged that the doctrine of proportionality is relevant. To appreciate the discussion on the point, it is necessary to realize that the removal of government and the dissolution of the assembly are effected by the president if he exercises powers of the governor under 164, 174, respectively, under subclause A of Article 356, though that is neither necessary nor obligatory while issuing the proclamation. In other words, the removal of the ministry or the dissolution of the Legislative Assembly is not an automatic consequence of the issuance of the proclamation. The exercise of the powers under subclauses A, B, and C of 356 may also coexist with the mere suspension of the political executive and the legislature of the state. Subclause C of Article 356 makes it clear. It speaks of incidental and consequential provisions to give effect to the objects of the emergency, of the proclamation, including suspension in whole or in part of the operation of any provision of the Constitution relating to anybody or authority in the state. It has to be noted that unlike subclause A, it does not exclude the legislature of the state. Subclause B only speaks of exercise of powers of the legislature of the state by or under the authority of Parliament. What is further the assumption of only some of the functions of the government and the powers of the governor or of any body or authority in the state other than the legislature of the state under subclause A is also conceivable with the retention of the other functions and powers with the government of the state and the governor or any body or authority in the state. The language of A is very clear on the subject. It must be remembered in this connection that where there is a bicameral legislature, the upper house, the legislative assembly, cannot be dissolved. Yet under subclause B of 356(1), its powers are exercisable by or under the authority of Parliament. The word used there is legislature, not legislative assembly. Legislature includes both lower and upper house, legislative assembly and the legislative council. It is also to be noted that when the powers of the legislature of the state are declared to be exercisable by or under the authority of Parliament under 356(1)(b), it is competent for Parliament under 357 to confer on the President the power of such legislature to make laws and to authorize the President to delegate the powers so conferred to any authority to be specified by him. The authority so chosen may be by the union or officers and authorities. Legally, therefore, it is permissible under 356, firstly, only to suspend the political executive or any body or authority in the state and also the legislature, and not to remove or dissolve them. Secondly, it is also permissible for the President to assume only some of the functions of the political executive or of any body or authority of the state other than the legislature, while neither suspending nor removing them. The fact that some of these exercises have not been resorted to in practice so far does not militate against the legal position which emerges from the clear language of 356. In this connection, we may refer to Dr. Ambedkar had to say on the subject of Constituent Assembly. The relevant extract from his speech is reproduced in para, which I've already read. Hence, it is possible for the President. Therefore, mothers, we need not read it this really. And then, sorry, mothers, the last paragraph. However, whether in a particular situation the extent of powers used is proper and justifiable is a question which would remain debatable and beyond judicially discoverable and manageable standards unless the exercise of the excessive power is so palpably irrational or mala fide as to invite judicial intervention. In fact, once the issuance of the proclamation is held and valid, the scrutiny of the kind and degree of power under this proclamation falls in a narrow compass. I just pause here. Whereas on the 21st of November, the governor had no power to dissolve Parliament. He could only do it under the on the aid and advice of the Council of Ministers. So see what they did. They knew that the Council of Ministers would never advise the governor to dissolve. So he dissolved it on his own. So if you dissolve it on your own, what are you left with? Only the governor. And then the governor, Malads, did what he did. You impose 356 and then you take over the powers. And Malads, ultimately, you are a delegate. 356 delegates the powers of the legislature to you. You're not an omnipresent, omnipotent authority to do what you like. You are a delegating. You've been delegated the powers of the legislature. What the primary institution cannot do, the delegate cannot do. So therefore, 356 was an extraordinary provision, allowing a progressive pathway for restoration. So what does that have done with this? Then,
Mr. Sibbal, you can perhaps give us the paragraphs. You can read them if they are on the same drift.
yes, I do.
Just give us the paragraphs so that
I'll
we'll read them later.
I'll give you the paragraph. Volume 2. Whereas therefore there's Justice Jeevan Reddy.
Which para?
268 and para 289.
Paras 268.
289, PDF 225. 268, 289, para, PDF 225.
Right.
Then Mullah's Justice Ahmadi, PDF 69, PDF 69, paragraphs 14, 16, and 23. Right? Yes, the rest I've read. This is what, yes, political act. Yes, the rest I've read. So this Malas completes
Yes,
350.
yes. What is the next judgment now?
Now, no, we've already read it. Well, yes, there's a speech of Ambedkar on constitutional morality, which I just want to mention. That is November 1948. Compilation, volume 8. I'll just do that. Document compilation, volume 8. PDF 3. Oh, sorry. 15, 1-5. Sorry. Right.
I think I cited it in the first Delhi judgment, the NCT judgment, 2018. Document compilation, 8 page.
Page, Madhur's 15, PDF 15. Running page 2876 at the bottom of it. Yes, it's also quoted, Madhur, in the Delhi matter. So my Lord doesn't, it's all right. We can move forward. So, Madhur, this is now, I've done with 356. We'll give your lordships the pages of the Delhi judgment also.
Yes, you can just give that.
Paragraph 284.
Where is the Delhi judgment? NCT?
Yeah, I'll just give your lordship the citation. Volume 5.
Case law, right?
Case law compilation, volume 5. PDF
At
paragraphs 284, 303, 284, 303, PDF pages 146 and 159. So PDF 146, 159, paragraphs 284, 303, right? So that's the Delhi judgment. Then, Madhurs, I want to cite to your lordships Miller's judgment. That's important. I'll just give you 3 paragraphs of Miller's to just show where it is.
Yeah, volume 6.
Volume 6. Volume 6, PDF 384.
PDF?
Sorry. What was my mistake? I'm sorry, but it's my mistake. Sorry. Volume 5, it is not 6. PDF 308, volume 5. And I just 3 paragraphs of that judgment that I will assign.
volume 5.
Only 5 page number?
It's
308.
PDF page 30. It's a PDF page 323 of volume 5. Straight to the paragraph that I'm reading.
Yes.
323, para 41. PDF. This is the case where the Queen was advised to prorogue Parliament. And 11 justices came down heavily, unanimous judgment. You can't just shut away discussion in Parliament. This is an extraordinary interpretation, showing that, look, you can't just show your back to the constitution, to the constitutional authority which has to deal with these issues. In our constitution, the right to prorogue is also given to the government. But of course, this principle is not really applied often. Now, C41, 2 fundamental principles. All your lordships have it. I'll read it. PDF 323. 5.
323.
I'm sorry?
320?
320.
323, madam. Running page 1446 at the bottom. I'm just waiting for Justice Kaur. Two fundamental principles of our constitutional law are relevant to the present case. The first is the principle of parliamentary sovereignty. That laws enacted by the Crown in Parliament are the supreme form of law in our legal system, with which everyone, including the government, must comply. However, the effect which the courts have given to parliamentary sovereignty is not confined to recognizing the status of the legislation enacted by the Crown in Parliament as our highest form of law. Time and again, in a series of cases since the 17th century, courts have protected parliamentary sovereignty from threats posed to it by the use of prerogative powers. And in doing so, have demonstrated that prerogative powers are limited by the principle of parliamentary sovereignty. In the context of Jammu and Kashmir, you use your prerogative power to erase the role of the legislature completely, to erase the opinion of the people of Jammu and Kashmir completely, to silence them through your own acts of majoritarian rule, which is a political act, according to me. To give only a few examples, in the case of proclamations, the court protected parliamentary sovereignty directly by holding that prerogative powers could not be used to alter the law of the land. Three centuries later, in the case of Attorney General versus Kaiser's Royal Hotel, 1920 appeal cases 508, the court prevented the government of the day from seeking it by indirect means to bypass Parliament in circumventing a statute through the use of prerogative. Exactly what's happened, Mullah. In fact, much more, circumventing the Constitution.
So, Sibyl, in a similar discussion we'll find in a 7-judge bench judgment in Krishna Kumar Singh.
Yes.
On the power to enact, to promulgate ordinances. Yes. And the question was...
Your lordships have said.
Yes.
In that judgment.
Can you, though the power is limited by duration and time, can you bring about irreversible changes by the exercise of the ordinance making power? And we said you can't do that.
I've relied on that. Absolutely. If it were an act of Parliament, right, Malaj, the situation may well be different. Because then you would have to attack the legislation itself, if at all it is permissible. But you're not, you're doing something through your prerogative power. And making structural changes in an embedded constitutional structure recognized by Parliament then in 1950. That's the problem in the case. So 3 centuries later, the court...
We'll look at this. There's no difficulty. We'll look. Para 42, the first sentence of para 42.
41, and then there are
42, the first sentence is important.
42 and 50.
And 50?
50.
At page?
Which is PDF page 326.
Actually, para 50 is the...
So, just 50 is important. It's a very small paragraph. I'll just read it. At PDF, page 326. It says, for the purposes of the present case, therefore, the relevant limit upon the power to prorogue can be expressed in this way, that a decision to prorogue Parliament or to advise the monarch to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing without reasonable justification the ability of Parliament to carry out its constitutional functions as a legislature and as a body responsible for the supervision of the executive. In such a situation, the court will intervene if the effect is sufficiently serious to justify such an exceptional clause. Anyway, so that's I've done with Nizar. Krishna Kumar, I'll give the citation only because it's your lordship's judgment.
17,
Is it part of the compilation?
It's volume 21, Mulats. Yes, it starts at PDF 2 at that volume, in that volume, volume 21. And the relevant part, PDF page 82, paragraph 101.
Para 101.
Para 101. And 103, re-promulgation in the present case, as well as 103. And that's PDF 83. PDF 82. So that's Krishna Kumar for your lordships. So we've done with this. So this topic now we've done with. Now let's come to Mulats. That's that itself. I've said that. 356 is only for temporary emergency legislation. Anyway, Mulats, so now we come to Mulats, the judgments, because several of the judgments in JFK have interpreted these provisions. So I just want to bring, up to speed. Compilation Volume 1.
These are judgments on Article 370 itself.
That's correct. That's correct. Yes, this one. Yes.
Which is the first judgment?
Just give me a minute. PDF page 2, Mulats.
Which volume?
This is volume 1 of the judgments, Mulats. This is Lakhan Pal versus State of Jammu and Kashmir. First matter. I intend to finish today, Mulats, so that.
Thank you, Mr. Sibal, for keeping to time.
Your lordship has been very kind.
I was going to tell you at 2 o'clock when we assemble, but sometimes, as a judge, you don't have the heart to do it.
No, I am very much.
But I'm sure that you do it.
Already sort of perhaps tested your patience more than.
No, not at all. Which?
Mulats, this page, first paragraph.
Which page?
Page 1, Mulats. PDF page 2. This is a Constitutional Bench judgment. Lakhan Pal versus State of Jammu and Kashmir. I won't deal with the reorganization, Mulats. There'll be other senior counsel will deal with it, but I'll broadly tell your lordships what the summation is. And then they can deal with it more elaborately. The application of a writ of habeas corpus is directed against the state of Jammu and Kashmir, which has by its order dated 4/10/1955 directed the detention of the petitioner under Section 3 of the Jammu and Kashmir Preventive Detention Act, hereinafter referred to as the Act. Originally, the sole respondent impleaded was the state of Jammu and Kashmir. After the rule Naisa was issued to the respondent, the Union of India intervened because the petitioner had challenged the validity of the constitutional application to Jammu and Kashmir Order 1954. Those are the facts, and the order is set out, Mullas, as PDF 4.
6.
PDF 4. Yes, I'm just reading the order. Yeah, that's the order. Whereas the government are satisfied that Lakhan Pal chairman so-and-so has a view to preventing him from acting in a manner prejudicial, it's necessary to make the order, and therefore they make the order. Then kindly come to paragraph 4. This order was to remain in force, Mullas, for 5 years. But it was extended. The petitioner contended that you can't extend this order. That's how the matter came up. So your lordships will find in paragraph 4, Act impugned in this case provides that it shall remain in force for a period of 5 years. Relevant portion is that. So let's skip that, Mullas. Then kindly come to paragraph 6. In the quoted portion, Mullas, in paragraph 6, PDF 6. No law with respect to preventive detention made by the legislature of the state, whether before or after the commencement of the constitutional application to Jammu Kashmir Order 1954, shall be void on the ground that it is inconsistent with any of the provisions of this part, but any such laws shall, to the extent of such inconsistency, cease to have effect on the expiration of 5 years from the commencement of the order, except as respects things done or omitted to be done. The effect of the modification in 35 is that such of the provisions of the Act are as consistent with Part 3 of the Constitution shall be valid until the expiration of 5 years from the commencement. This is an exception which has been engrafted on the Constitution in respect of fundamental rights relating to personal liberty for a period of 5 years. The Act itself has a limited life of 5 years, thus exception aforesaid is coextensive with the life of the Act itself. Hence, so long as the Act continues in force in its present form, the provisions of Articles 21, 22, insofar as they are inconsistent with the Act, are out of the way of the respondent, and the petitioner cannot take advantage of those provisions. Therefore, there is no question of the provisions of Section 8 of the Act being unconstitutional, by reason of their being inconsistent with 21 and 22. Then paragraph 8. Mullahs, he realized, the petitioner realizing the difficulty, Mullahs. Realizing the difficulty in the petitioner's way in view of the provisions of clause C added to Article 35, the learned counsel of the petitioner faintly suggested that clause C of 35 added by the presidential order was itself bad, as so the argument further ran that provision was in excess of the powers conferred by the president on the president by 370. No attempt was made on behalf of the petitioner to show how the order promulgated by the president was in excess of the powers of 370. It was not contended that the article did not authorize the president to promulgate the order. What was suggested was that the promulgating the order, which the president was authorized to make under 370, had exceeded his powers. This argument was ultimately rejected. So the detention was upheld. Then, Mullahs, the next judgment is Premnath call. This relates to land. Right.
लखनपाल में कुछ खास नहीं है.
And Mullahs, paragraph, this is also a constitutional bench judgment. That's Mullahs PDF 8. A suit was filed by the appellant in a representative.
Lakhanpal, nothing really turns much, I think.
No, nothing much. That's right. But then those provisions were extended, Mullahs, from time to time. This particular issue came up, Mullahs, kindly see, this is important, page 8. PDF page 9. Paragraph 6.
Para 6.
6 and 7. What happened was, Mullahs, in dealing with this appeal, it's necessary to relate some detail the events that took place in Kashmir and the constitutional changes which followed them in order to appreciate fully the background. A clear understanding of this background will help us deal with the appellant's case in its proper perspective. In 25, Hari Singh succeeded Pratap Singh as the ruler. It appeared that for some time prior to 34, there was public agitation in Kashmir for establishment of responsible government. Presumably, as a sequel to the said agitation, Hari Singh issued Regulation 1 of 91. The regulation began with a statement of policy that it had the declared intention of the Maharaja to provide for the association of his subjects in the matter of legislation and the administration of the state, and that it was in pursuance of the said intention that the regulation was being promulgated. Regulation consisted of 46 sections, which dealt with the legislative, executive, and judicial powers of the Maharaja, referred to the subjects which had to be reserved for the operation of regulation, made provision for the constitution of the legislature of a state, conferred authority on the council to make rules for specified purposes. It is relevant to refer to only 2 sections of this regulation. Section 3 provides that all powers, legislative, executive, and judicial, in relation to the state and its government are hereby declared to be and to have been always inherent and possessed and retained by His Highness, the Maharaja of Jammu and Kashmir, and nothing contained in the regulation shall affect or deem to affect the right of the prerogative of His Highness to make and pass regulations. These regulations, passing of these regulations was challenged, and ultimately the court held, but this power is retained by the Maharaja. So therefore you can't really challenge them, despite the fact that we are in the year 1959. So those powers continued, and ultimately, the court upheld them. Well, let's kindly see para 12 at PDF 10. Meanwhile, the invasion of the state had created tremendous popular fervor and patriotic feelings in resisting the act of aggression, and this popular feeling inevitably tended to exercise pressure on the Maharaja for introducing responsible and popular government. Maharaja tried to pacify the popular demand by issuing a proclamation on March 8, 1948. By this proclamation, he stated that in accordance with the traditions of his dynasty, he had from time to time provided for increasing association of his people with the administration of the state with the object of realizing the goal of full responsible government at as early a stage as possible. And he added that he had noted with gratification and pride the progress made so far and the legitimate desire of his people for the immediate establishment of fully democratic constitution based on adult franchise with a hereditary ruler from his dynasty as the constitutional head of an executive responsible to the legislature. Remember, by this time, the 1957 Constitution of Jammu and Kashmir had come into play. So the argument was, how do you expect this Maharaja to continue with the power when we have a constitution of our own? So therefore, this power and this proclamation issued by him is bad. It's in that context that the judgment is rendered. It appears that before this proclamation was issued, the Maharaja had already appointed Sheikh Muhammad Abdullah, who was then the popular leader of the people, at the head of the emergency administration. By the proclamation, the Maharaja replaced the emergency administration by popular interim government and provided for its powers, duties, and functions pending the formation of fully democratic government. Clause 1 of proclamation provides for the composition of the ministry. You Lordships may leave that, Malas. By this, straight away come to para 23. PDF page 14, paragraph 23. This was the contention of in the suit, which ultimately came to the Supreme Court. The validity of the act is impeached mainly on the ground that Yuvraj Karan Singh had no authority to promulgate the said act. It is this argument which has been urged before us by Mr. Chatterjee in different and alternative forms needs careful examination. The first attack against the competence of Yuvraj proceeds on the assumption that at the time when the Maharaja Hari Singh conveyed his powers to Yuvraj by his proclamation in 49, he was himself no more than a constitutional monarch, and as such he could convey to Yuvraj Karan Singh no higher powers. Let us first deal with this argument. Prior to the passing of the Independence Act, the sovereignty of Maharaja Hari Singh over the state of Jammu and Kashmir was subject to such limitations as were constitutionally imposed on it by the paramountcy of the British Crown and by the treaties and agreements entered into between the rulers of the state and the British government. It cannot be disputed that so far as the internal administration and governance of the state were concerned, Maharaja Hari Singh, like his predecessors, was an absolute monarch, and that all the powers, legislative, executive, and judicial, in relation to his state and its governance inherently vested in him. The position has been emphatically brought out by Section 3 of the regulation, though by this regulation, Hari Singh gave effect to his intention to provide the association of his subjects in the matter of legislation and administration. By Section 3, he fully preserved to himself all the existing legislative, executive, and judicial powers. Section 3 not only preserves the said powers, but expressly provides that nothing contained in the regulation shall affect or deem to have affected the right and prerogative of His Highness. But as your Lordships may leave this now, and then it is, however, urged that the constitutional position, substantially altered by the subsequent Constitutional Act of 1996, we are unable to accept this argument. 4 and 5 of this Act in terms continue to preserve the powers, legislative, executive, and judicial, as well as the right and prerogative of His Highness, just as Section 3 of the regulation of 1991. So, but they uphold it, even though there is a Praja Sabha at that time. They said the Maharaja's powers are intact. But of course, the situation has completely changed now. You no longer have the Maharaja. So now all the powers are with the legislature. So in a sense, this is a it's a pre-1957 situation, which preserved the powers of the Maharaja till the Maharaja had to give up his powers. So let's not. That's all right. And let's quickly now. Now, kindly see 34. Just 1 minute. 34, PDF 19. Having provided for the legislative power of Parliament and for the application of the articles of the Constitution, Article 370, Clause 2 prescribes that if the concurrence of the government of the state required by the relevant sub-clauses of Clause 1 has been given before the Constituent Assembly of Kashmir has been convened, such concurrence shall be placed before such assembly for such decision as it may take thereon. This is what I was saying in the morning as well. Even in respect of laws passed, mothers, the concurrence of the Constituent Assembly was necessary. This clause shows that the constitution makers attach great importance to the final decision of the Constituent Assembly. And the continuance of the exercise of powers conferred on Parliament and the President by the relevant temporary provisions of 371 is made conditional on the final approval by the said Constituent Assembly in such matters. Clause 3 authorizes the President to declare by public notification that this article shall cease to be operative or shall be operative only with specified exceptions and modifications. But this power can be exercised by the President only if the Constituent Assembly of the state makes recommendation in that behalf. This is also a Constitution Bench judgment.
Well, which para is this, Mr. Sibil?
This is para 35.
What's the year of the judgment?
1959. Sorry. Give the year, please. 59. After the Constitution of Jammu and Kashmir comes. And this is a Constitution Bench judgment. Clause 3 authorizes the President to declare by public notification that this article shall cease to be operative or shall be operative only with specified exceptions or modifications. But this power can be exercised by the President only if the Constituent Assembly of the state makes recommendations on that behalf. Thus, the proviso to Clause 3 also emphasizes the importance which was attached to the final decision of the Constituent Assembly of Kashmir in regard to the relevant matters covered by 370. This is how this court also understood it. The appellant contends that the scheme of this article clearly shows that the person who would be recognized by the President as the Maharaja of Jammu and Kashmir was treated as no more than a constitutional ruler of the state. In regard to matters covered by this article, he could not function or decide by himself and his own discretion. The constitution contemplated by this article had to be with the Maharaja acting on the advice of the Council of Ministers, and the concurrence prescribed by it had to be similarly obtained and given. And that brings out the limitations of the powers of the Maharaja. It is also urged that the final decision in these matters had been deliberately left to the Constituent Assembly, which was going to be convened for the framing of the Constitution of the state, and that again emphasizes the limitations imposed. This argument assumes that under Article 370, sub-Article 1, it is the person recognized by the President as the Maharaja who has to act on the advice of the Council of Ministers in relation to matters covered by 370. But it is possible to take the view that the said clause really indicates that in recognizing any person as the Maharaja of the state, the President has to act on the advice of the Council of Ministers for the time being in office under the Maharaja's proclamation dated 5th March 1948. If that be the true construction of the explanation, then the argument that before the Maharaja is consulted or its concurrence is obtained, he must act on the advice of the ministers would not be valid. We would, however, like to deal with the argument even on the assumption that the construction put by the appellant, the explanation is right, and then they deal with it. On the said construction, the question which falls for consideration is, do the provisions of 370 affect the plenary powers of the Maharaja in the matter of governance of the state? The effect of the application of the present article has to be judged in the light of its objects and its terms considered in the context of special features of the constitutional relationship between state and India. The constitution makers were obviously anxious that the said relationship should be finally determined by the Constituent Assembly of the state itself. Mark these words, please. That it is the main basis and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to its subject matter. It would not be permissible or legitimate to hold that by implication the article sought to impose limitations on the plenary legislative powers of the Maharaja. These powers had been recognized and specifically provided by the Constitution Act of the state itself, and it was not and could not have been within the contemplation or competence of the constitutional makers to impinge even indirectly on the said powers. It would be recalled that the instrument of accession those powers have been expressly recognized and preserved, and neither the subsequent proclamation issued by Ruvraj, adopting as far as it was applicable the proposed Constitution of India, nor the Constitution order subsequently issued by the President, purported to impose any limitations on the said legislative power. What form of government the state would adopt was a matter which had to be and naturally was left to be decided by the Constituent Assembly of the state. Until the Constituent Assembly reached its decision in that behalf, the constitutional relationship between the state and India continued to be governed basically by the instrument of accession. It would therefore be unreasonable to assume that the application of 370 could have affected or was intended to affect the plenary power. So, this is how this court, Constitution bench of this court, interpreted 370. And then, they refer to 245, 254 and say that those provisions were not applicable anyway. Then it says, it is difficult to see how this article supports the appellant's contention. In fact, it is not easy to appreciate what the application of this article to the state meant. As we have already pointed out, the application of the specified articles to the state was not intended to affect and constitutionally could not have affected the form of government prevailing in the state and the plenary legislative powers of the Maharaja. And that was all the rest is. So that gives you an indication as to how a constitutional bench of this court looked at 370. And in the context of the Constituent Assembly, leaving it to the Constituent Assembly to decide upon the relationship between the state and the Union of India at that point in time. The next is Lakhanpal somehow this is not necessary. This is the second Lakhanpal where the detention, again he challenges detention, and the law on detention was extended to 15 years, and therefore that detention was also upheld. So we'll skip the second Lakhanpal. Yes. Yes, sorry. No, it's not detention. It's the second one, Sampat Prakash Das detention. This is a case, where members were sent at the instance of the legislature to Parliament on a recommendation of the legislature, which was a special provision in 81 of the Jammu Kashmir Constitution, and said that, look, there can be no direct election. It has to be at the three of them. A few of them have to be at the instance of the legislature, on the recommendation of the legislature. Really speaking, the core issue is it's all right. Let's not go into it. Sampath Kumar was this. Well, this was a case of detention, again a case of detention. And kindly come to paragraph. And the law of detention was extended from time to time till it was for 15 years at a stretch. And that detention order was challenged. But let's see that PDF 29, paragraph starting the first argument. Yes. Continuation of paragraph 4 at PDF 28. He challenged his detention order, and the first argument he made was the following. PDF 29, what's the time? Finish. My lord has that?
They say that the power of the president to make modifications is of the widest amplitude.
That's Lakhanpal.
That's Lakhanpal.
Yeah. Lakhanpal 2, right?
And that the power to make a modification includes the power to make an amendment to the constitution.
Yes, yes. And that is also with the concurrence, Malaj. It's not without concurrence. That's not without concurrence, Malaj.
Yes, that's right. That concurrence was not an issue there.
Just saying, Malaj. It's not in the absence of concurrence. It's
obvious.
But 368 is therefore not really applicable as well. Because you're not amending the main constitution.
That's right. That's right. Absolutely right. Doubtable. Doubtable. Now, Malaj, now in this Sampath Prakash, PDF Malaj 29, and I'm inviting my lords to paragraph 4 at PDF 28 at 29, the PDF 29, the first argument. The first argument, no, my lord has that. The first argument was that this article contained temporary provisions which ceased to be effected after the Constituent Assembly convened for the purpose of framing the Constitution of Jammu and Kashmir had completed its task by framing the Constitution of that state. Reliance was placed on the historical background in which Article 370 was included in the Constitution to urge that the powers under the article were intended to be conferred only for the limited period under the Constitution of the state was framed, and that the President could not resort to them after the Constituent Assembly had completed its work by framing the Constitution of the state. The background of the legislative history to which reference was made was brought to our notice by learned counsel by drawing attention to the speech of Gopalaswamy Iyengar, which your lordship read, when he moved in the Constituent Assembly clause 306A of the bill, which now corresponds to 370. It was stated by him, the condition that leave that out, Mullah. Then, further down, Mullah, after those 7 items, learned counsel urged that in this background, 370 of the Constitution could only have been intended to remain effective until the Constitution of the state was framed and the will of the people of Jammu and Kashmir had expressed. And thereafter, this article must be held to have become ineffective. So that the modifications made by the President in exercise of the powers under this article, subsequent to the enforcement of the Constitution of the state, would be without any authority of law. The Constitution of the state came into force on 26 January 56, and therefore the 2 orders, 59 and 64, passed by the President in perpetuate exercise of power under 370 were void. It was also urged that the provisions of Clause 2 of Article 370 support this view. It would also urge that the provision support this view because it directs that if the concurrence of the government of the state is given under Para 2 of Subclause B of Clause 1, or under the second proviso to Subclause D of that clause before the Constituent Assembly for the purpose of framing the Constitution of the state is convened, that concurrence had to be placed before such assembly for such decision as it may take thereon. From this, it was sought to be inferred that the power of the President, depending on the concurrence of the government of the state, must be exercised before the dissolution of the Constituent Assembly of the state, so that the concurrence could be placed for its decision, and that power must be held to cease to exist after the dissolution of the Assembly. Were not impressed with either of these 2 arguments advanced by Ramamurthy. So far as the historical background is concerned, the Attorney General appearing on behalf of government relied on it to urge that the provisions of 370 should be held to be continuing in force. This is important. Continuing in force because the situation that existed when this article was incorporated in the Constitution had not materially altered. And the purpose of introducing this article was to empower the President to exercise his discretion in applying the Indian Constitution while that situation remained unchanged. There is considerable force in this submission. The legislative history of this article cannot in these circumstances be of any assistance for holding that the article became ineffective after the Constituent Assembly of the state had framed the Constitution. And then, Mullahs, ultimately, Para 7 is important. There are, however, much stronger reasons for holding that the provisions of this article continued in force and remain effective even after the Constituent Assembly of the state passed the Constitution of the state. The most important provision in this connection, kindly note that is contained in clause 3 of the article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications, and from such date as the President may specify by public notification, provided that the recommendation of the Constituent Assembly of the State referred to in clause 2 shall be necessary before the President issues a notification. Well, that's what I was trying to tell my Lord Justice Khanna. Before, this is a Constitutional Bench judgment. This clause clearly envisages that the article will continue to be operative and cease to be operative only if, on the recommendation of the Constituent Assembly, the President will make a direction to that effect. In fact, no such recommendation was made by the Constituent Assembly of the State, nor was any order made by the presiding President declaring that the article shall cease to be operative. On the contrary, it appears that the Constituent Assembly of the State made a recommendation that the article should be operative, with one modification to be incorporated in the explanation of clause 1 of this article. This modification in the article was notified by the President by the Ministry of Law, CO 44 dated 15 November 52, and laid down that the 17th November 52, the article was to be operative with substitution of the new explanation for the old explanation as it existed at that time. This makes it clear that the Constituent Assembly of the State did not desire this article should cease to be operative, and in fact expressed its agreement to the continued operation of this article for making a recommendation it should preserve.
That's one minute.
Yeah. The next submission made for challenging the validity of the orders of modification made in 59 and 64 was that subclause D of clause 1 of 370, the power that is conferred on the President is for the purpose of applying the provisions of the Constitution to Jammu and Kashmir, and not for the purpose of making amendments in the Constitution as applied to that state. The interpretation sought to be placed was that at the time of applying any provision of the Constitution to the state of Jammu and Kashmir, President is competent to make modifications and exceptions therein. But once any provision of the Constitution has been applied, the power under 370 would not cover any modification in the Constitution as applied. Reliance was thus placed on the nature of the power conferred on the President to urge that the President could not, from time to time, amend any of the provisions of the Constitution as applied to the state of Jammu and Kashmir. It was further urged that the presidential power under 370 should not be interpreted as applying Section 21 of the General Clauses Act, because the constitutional power cannot be equated with the power conferred by the Act. Whereas the court ultimately relied on 21. The argument, in our opinion, proceeds on an entirely incorrect basis. Under 3671D, the power of the President is expressed by laying down the provisions of the Constitution other than Article 1 of 370, which under 371C became applicable when the Constitution came into force, shall apply in relation to the state of Jammu and Kashmir, subject to the exceptions and modifications that the President may order specified. What the President is required to do is to specify the provisions of the Constitution which are to apply to the state of Jammu and Kashmir. And when making such specification, he is also empowered to specify exceptions and modifications to those provisions. As soon as the President makes such a specification, provisions become applicable to the state with the specified exceptions and modifications. The specific The specification by the President has to be in consultation with the government of the state if those provisions relate to matters in the union list and the concurrent list specified in the instrument of accession, governing the accession of the state to the Dominion of India, as matters with respect to which Dominion legislature will make law. The specification in respect to all other provisions, that is subclause D, clause 1 of 370, has to be with the concurrence of the state government. Any specification made after such consultation or concurrence has the effect that the provisions of the Constitution specified with exceptions and modifications become applicable to the state of Jammu and Kashmir. Cannot be held that the nature of the power contained in this provision is such that Section 21 must be held to be totally inapplicable. So, that's it, Malad, as far as. No, para 14, sorry. It was also urged, para 14, PDF, Malad, 33. It was also urged that the power of making modifications and exceptions in the orders made by Article 371D should at least be limited to making minor alterations, not cover the power to practically abrogate an article of the Constitution applied. That submission is clearly without force. Challenge to the validity of 35C introduced to the Constitution as applied to Jammu Kashmir on this ground was repelled by the court in Dakhanpal. Subsequently, the scope of the powers of making exceptions and modifications was examined. So, Madam, as long as the exceptions or modifications are made with consultation or concurrence, depending on the instrument of accession or the concurrent list matters, Madam, there's no issue at all. The President could do it. But beyond that, no. Madam, now, therefore, now this is the case that the other side is relying upon. That was C67. This is the important case. That is PDF 36, same volume. Makbul Daman. It's a 32 petition. Again, a detention matter. What's the time? Yes, then I'll finish. After this, I'll touch for 5-10 minutes on the Reorganization Act. The rest others will do. I have done. Well, let's, Mr. Garg, but this is again a detention matter, who appeared on behalf of the petitioner, raised the following points. Paragraph 6 at page 40. Very inspirational lawyer, Mr. Garg was. Yes. He would be sitting at the back of this court and pretend to be sleeping when he would suddenly wake up. He would suddenly wake everybody up, including himself. And he'll tell the court that they were wrong or they were right. An amazing personality. And wedded to the cause of at least in matters of preventive detention, and always appearing for the weak and for the marginalized. Always. We owe him a lot. Mr. Garg, who appeared on behalf of the petitioner, raised the following points before us. That the Jammu Kashmir preventive detention, herein referred to as the amending act, was invalid as it was assented to by the Sadr-e-Riyasat. Not invalid, as was not assented to by the Sadr-e-Riyasat. It was assented to by the governor, but he said the Sadr-e-Riyasat was directly elected. The governor was not directly elected, so therefore this is completely unconstitutional because he did not give his assent to it. That the proviso inserted by 4.2 of Section 8 is bad because it suffers from excessive delegation. There has been no violation of Article 21-22. At any rate, the proviso is bad because it conflicts with Section 103 of the Constitution. The detention order is bad because the detaining authority has not applied its mind, and the order of detention is bad because it is not served or executed in accordance with law. In support of his contention, learned counsel urged that 370 was the only authority which is recognized as the government of the state of Jammu Kashmir is the Sadr-e-Riyasat. 370 contemplates that Sadr-e-Riyasat would be the head of the state of Jammu Kashmir, and Jammu Kashmir Assembly had no power to abolish the office of Sadr-e-Riyasat. He further urged that Section 147 of the Constitution, which I have read to your Lordship, also contemplates that the Sadr-e-Riyasat shall exist and be the head of state. He urged that the only possible way of getting rid of the Sadr-e-Riyasat would be to amend the Constitution of India as applied to Jammu Kashmir. The Attorney General who appeared on behalf of the government, Mr. Chagla, who appeared for the state, contended that the Constitution of Jammu Kashmir, which had received the assent of the Sadr Riyasat, validly amended the Constitution of Jammu Kashmir and validly provided for appointment of a governor in place of Sadr Riyasat, and therefore the governor was competent to give assent to the Jammu Kashmir preventive detention. That was this limited issue, that the Sadr Riyasat was directly elected, governor was appointed, the Sadr Riyasat never gave his consent. Therefore, this detention law where the governor gave consent is bad. Then straight away, 13 minutes. Paragraph 13 at PDF 42. On January 26, 1950, the constitutional application of Jammu Kashmir Order 1950 was made by the President. On April 20, 1951, the Maharaja of Jammu Kashmir issued a proclamation in pursuance of which the Constituent Assembly of Jammu Kashmir was convened on November 5, 51. On June 10, 1952, the principals of the Committee of Jammu Kashmir's Constituent Assembly submitted an interim report. Then para 14. The Constituent Assembly by a resolution adopted these recommendations. The following part of the resolution is relevant. Now, therefore, in pursuance of the resolution dated 12 June 52, and having considered the report of the drafting committee, this assembly resolved that the head of the state shall be the person recognized by the President of Union on the recommendations of the Legislative Assembly. Later on, Mullah, it was directly appointed. Sorry? Oh, I see. I'm sorry. The head of state shall be the person. He shall hold office during the pleasure of the President. He may, by writing under his hand, address to the President, resign his office. Subject to the foregoing provisions, the head of state shall hold office for a term of 5 years from the date he enters upon his office. And then, Mullahs, provided that he shall, notwithstanding the expiration of his term, continue to hold office until his successor enters, that the recommendation of the Legislative Assembly of the state in respect of recognition of the head of state shall be made by election. Then, Mullahs, November 16, 1952, the explanation was, Mullahs, in a way, it was amended by a recommendation of the Constituent Assembly. Just mark that, Mullahs. In exercise of the powers conferred by this article, the President, on the recommendation of the Constituent Assembly of the state, declared that as from 17th day of November, the said 370 shall be operative, with the modification that for the explanation in clause 1 thereof, the following explanation is substituted. For the purpose of this article, the government of the state means the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as the Sadr Riyasat of Jammu and Kashmir, acting on the advice of the Council of Ministers. So when this argument was raised, the court ultimately came to the conclusion that in essence, this Sadr Riyasat is a governor. So there is no substantial change. Then go, let's directly to 19, Malas. PDF page 44. I'm trying to, Malas, hasten the pace so that. On November 1756, Jammu and Kashmir Constitution was adopted. Some sections came into force on the day of and remaining sections came into force in 57. Then Miller's few lines thereafter on November 2465. This is important. The President, in exercise of the powers by clause 1 of Article 370, with the concurrence of the government of Jammu and Kashmir, made the Constitution application to Jammu Kashmir's Second Amendment Order 1965 for subclause B of clause 4 of 367. Lordship sees that? The following clauses were inserted. References to the person for the time being in force recognized by the President of the recommendation of Legislative Assembly as the Sadr Riyasat, acting on the advice of the Council of Ministers of the State for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And references to the government of the said state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. Then para 21, according to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at that time. What are the constitutional conditions? Well, every state had a governor. He was not directly elected. And Constitution of Jammu and Kashmir itself stood amended. in 1965, Malas. And the head of the state was to be the governor. So according to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at the time. According to Mr. Garg, this is the kingpin of the whole relationship between the Union of India and the state of Jammu and Kashmir. According to him, neither the Jammu and Kashmir Assembly nor the President were competent to impair the functioning of the Sadr-e Riyasat insofar as the Constitution of Jammu and Kashmir, Sixth Amendment Act 1965, replaced the Sadr-e Riyasat by the governor is ultra-vires. According to him, either there has to be an amendment to the Constitution of India under 368 and 373, or a fresh Constituent Assembly had to be convened to amend the explanation. He said that if the text of the Constitution is explicit, effect must be given to it, and it is not the duty of the courts to improve upon the Constitution because the Constitution makers had not anticipated it. So, the court rejects that argument. And then, at page 24, this para 24 is the heart of the matter. The Learned Counsel, relying on Sampath Prakash, contended that the only way of modifying 370 is specified in Article 370, sub-Article 3 itself. He said that this was expressly laid down by this court in a decision referred to. We are not concerned with the question whether Article 373 can now be utilized to amend the provisions of 371 or 2, and therefore we do not express any opinion on that point. We are now not concerned with an amendment to Article 370, subclause 1. We are concerned with a situation where the explanation ceased to operate. It has ceased to operate because there is no longer a Sadr-e Riyasat in Jammu and Kashmir. Now, next is important. If the definition contained in the explanation cannot apply to the words government of the state, since the meaning of Article 367(4) is amended, will have to be given to it. It is this meaning, if this meaning is given, it is quite clear that the governor is competent to give the concurrence stipulated in Article 370. And then, Malaks, kindly come straight away to para 29.
Para?
PDF page 47. I had Malaks, your PDF page 47. If we had regarded this as an amendment to Article 370, Clause 1, then we would have had to consider whether the amendatory powers had been validly exercised or not. But as we have said, we're not concerned with that question.
Which para is this?
This is 29.
29.
Yes. So clearly, Damnu is not for a proposition that you can amend 370 in this process by virtue of 367(4). That's what the union has tried to apply. That Damnu has already decided this issue. So, now I am finished with the judgments also. Now I'm left with the last, which I'll finish by 4 o'clock. 15 more minutes.
That's the reorganization.
That's the Reorganization Act. Now, let's go to the, first of all, so Jammu and Kashmir, Constitution of India as applicable to Jammu and Kashmir, Article 3. This is at document volume 2, PDF page, 1, not 2. PDF page 65. Article 3. So I've shown you what's the proviso already in Article 3, that no bill shall be introduced in Parliament without the consent of the legislature of the state. And I've shown to your lordship the August 5, the bill was introduced. Now see the Constitution of India along with this Article 3 of the Constitution. I'll just make a brief argument so that then others can, if they so choose, we say with
Article 3, right?
Constitution of India, Article 3. Formation of new states and alteration of areas, boundaries, or names of the existing states. Parliament may by law, my lords have that, may by law form a new state by separation of territory from any state. So if you have a large state, you can form a new state by separation of territory of any state, or by uniting two or more states. So you can form a new state by uniting two or more states, or parts of states, or by uniting any territory to a part of any state. That's the way you form states, brothers. Or you bifurcate states. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. Provided that no bill for the purpose shall be introduced to either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred to by the President to the legislature of that state for expressing its views thereon, within such period as may be specified in the reference, or within such period as the President may allow. The period so specified or allowed has expired. Explanation. This is important. In this article, in clause A to E, state includes a union territory, but in the proviso, state does not include a union territory. The power, then explanation 2, the power conferred on Parliament by clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. Normally, if you're going to read in explanation 1, state includes a union territory. Let's go back to the definition now. Let's see how it fits in. So now you say, form a new union territory. Let's read the word instead of state as union territory. If you, Malads, substitute the word union territory wherever the word state is used, this article will make no sense. And I'll read it in that fashion. Form a new union territory by separation of territory from any union territory.
No, but it could be by separation of territory from any state.
That's correct. So therefore you can't read, therefore only in the first part you will read union territory. That's my submission. In other words, form a union territory by separation of territory from any state. You can do that. Or by uniting two or more states, you can have a union territory. Or parts of states, you can have a union territory. Or by uniting any territory to a part of any state. How can you create a union territory for Jammu and Kashmir under this article? You can't do it. You can carve out a union territory. You can't create a union territory under Article 3 and convert it into a state into a union territory. That's contrary to all principles of representative form of government. It doesn't allow extinguishment of a state completely. Can you say that tomorrow Madhya Pradesh will be a union territory or Bihar will be a union territory? You can do it to one, you can do it to all. You can have a presidential form of government, create all states, convert all states into union territory. By what stretch of imagination
But what about textually?
I'm sorry?
Textually. The other argument is, of course, that you can't do it because you said representative democracy, but textually can you not do it?
No, because I'm saying you form a union territory by separation of a territory from a state. From any state. Or by uniting two or more states or parts of a state. This is not that exercise at all. You have created two union territories from a state. Where is that power? Well, there are multiple categories. What they have done doesn't fall in any of these categories. You can carve out a union territory. If you have two or more states come together, you can carve out a union territory. If a part of a state, you can carve out a union territory. But you can't create two union territories in a state. How is that possible? Apart from what my lord said, representative form of government, you can't. You're not going back, Madas. Moving away from a representative form of government. This is not a reverse.
What the same says, common.
Yes, yes, that was possible. Whereas you could have kept Ladakh, Madas, as a union. I'm sorry.
Parameter. The report is there on record.
I won't go into it, my colleagues will, which tells you as to how the union thought as to how union territories are to be created. In 1953, way back, there's a State Reorganization Commission. My learned friends will refer to it. I don't want to do that. But essentially, there are two aspects to this. The text of the Constitution doesn't allow you to do that. And the fundamentals of constitutional democracy don't allow you to do that. You can't go back in time, move from representative.
My judgment in NCT 2 traces the history of how you had the Part A, Part B, Part C state. How then, after the 7th Amendment, you replaced the Part B and Part C states and the union territories were created.
And NCT judgment deals with asymmetric federalism. It's a case of asymmetric federalism. Of course, now they've done something else, so that your lordship will hear now. Another way. Otherwise, Maharaj, this power can be exercised at any time.
Okay,
Yes. Yeah. words, Malad. Where is the voice of the people of Jammu and Kashmir? Where is the voice of representative democracy? 5 years have passed. Have you heard, Malad? Any representative form of government? When you convert a whole state, Malad, this way all of India can be converted. This power is given. And Malad, the proviso said you have to take the consent. You do away with that through an executive act. You don't even take their views. You become the legislature yourself. So where do we stand, Malad? We stand at a situation where, Malad, though the Constitution is a political document, its provisions can't be manipulated and maneuvered for political ends. It cannot be. That's not how you interpret a constitution. It is a political document, but you cannot politically misuse it and maneuver it and manipulate it, which is what has been done. That can't be done. And even when there is a clash of arms, the law is never silent. The law is not concerned with that. The court is never silent. And whenever the court has been silent, the consequences have been disastrous. It's time for your lordships. And what is a constitution? A constitution is a set of values. Values on the basis of which people will represent themselves and their voice will be heard. If you, through such executive acts, silence the voice of the people, what is left of democracy? And all that I can say to your lordships is that this is a historic moment. Historic not for the present, but for the future of India. And I hope this court is not silent. Thank you.
Thank you very much,
Only
Mr.
one-
Subba. Thank you.
Only one
Who
thing.
will follow now?
What was, just my lord, since this occurred, my lord, on the union territory part, the lordship would also examine, my lord, after the court is over.
Yes.
What was read was the provisions of Article 3 as applicable to Jammu and Kashmir then. Thereafter, the entire constitution is applied before the reorganization took
Yes,
place.
yes, that's what
And
we are
therefore,
telling you.
please read as applicable to entire country.
I read
Your
both.
lordship would get the answer.
I read
Was
both
a little
applicable
bit-
as well as the constitution. My direction is wrong. I read both. I was reading the Constitution Article
The
3.
explanation
Both.
was not written. Really
What are you saying?
Was a
I don't know. Obviously, you didn't even hear what I said. So therefore, he was silent when I was arguing, Manoj.
I can't interrupt him.
Mr. Zafar Shah will be arguing now.
Lord, I beg to appear, my lord, after Mr. Sibal.
All right. Mr. Subramaniam, which area would you be covering broadly?
My lord, I will be covering some parts of the unfinished, if I may say so, portions of Mr. Sibal. Largely, I wouldn't take very long. Your lordships may be assured of that. But there are some points, my lord, which need to be cemented, particularly with reference to the decision of the Constituent Assembly of Jammu and Kashmir itself.
So we begin tomorrow morning. Mr. Subramaniam, can we request you to complete by lunch tomorrow?
I think, my lord, that's a very fair suggestion.
After that, who will be the next person in line?
So, yes, certainly. Then we will hear, so Mr. Subramaniam will take through to lunch tomorrow, and then you can, how long would you take? Okay, by the end of the day.
से पूछ ले दिन तो हो गया
Right.
टेंशन नहीं हुआ और होगा